All right, great. Good afternoon, everybody. Welcome to the October 28th, 2025 MFRAC meeting. My name is Vijay Kapoor. I have the honor of serving as the receiver for the city of Chester. Joined at this meeting today is the Honorable Mayor Stefan Roots from the city of Chester, the Honorable Councilman Shaquan Davis, also from the city of Chester, Ms. Kelly Diaz from Delaware County, and Mr. Andrew Sheaf from DCED. Good afternoon, everybody.
Good afternoon.
Afternoon.
Also joined by my executive assistant, Mr. Cody Deal of DCED. Good afternoon, Mr. Deal.
Good afternoon.
Great. We do have some important, I do have an important presentation that I want to talk about today. But before that, let's go through our regular agenda. Mr. Deal, have you circulated any public comment that we have received?
Thank you, Mr. Receiver. No public comments were received since our last meeting, so nothing has been circulated. As always, would just like to encourage the public again to reach out to the committee. The best way to do so is through our resource account email address, which is info@chesterreceivership.com. Again, that's info@chesterreceivership.com.
Great. Thank you, Mr. Deal. Before we get to the presentation that I wanted to make here before the committee, did anyone have any updates or any news that they wanted to provide the public or the committee?
Well, I'll join
Mr.
in.
Mayor?
News is the operative word here. I hope all of you saw, and if you didn't, the Philadelphia Inquirer has a great story that's entitled "Chester Saw One of Its Safest Summers Ever in 2025. No one died from gun violence." That just tells the whole story right there. One of the things that I'm very high on as mayor of Chester is reputation management. We are constantly bombarded with all the bad stories in the press when it comes to Chester. And the only way to combat that is to fight back with good news. So over the last couple of years, we've put out a number of press releases that announce the good news and the changes that have gone here. We've used social media in ways that have never been used before. But when you get earned press, like a reporter literally coming from another town, the big city up the street, and interview the players responsible for the safest summer ever in 2025, that's a big deal. It was a little surprising, and you wouldn't know this unless you knew this. This interview took place probably 3 weeks ago. So I've been on edge waiting for this story to drop, but it finally did drop. And it's just it's a testament to the fact, and it's being broadcast to the entire audience of the Philadelphia Inquirer, which is large, not just locally, but through the press and the links, literally all over the world. The response I'm getting is bonkers. What it says is that the connective tissue is working. The mayor's office, the police department, the folks out on the street, the DA's office are all combining to make things happen, particularly in the summer months where we generally anticipate an uptick in violent crime. This year, there was none with regard to gun violence. It just represents the work that we're doing here, and it becomes the mark that we're going to always achieve moving forward. So really excited about the news that came out in the Philadelphia Inquirer on Monday, October 27th. The other thing I want to announce was a real surprise, and that is that the ambassador to Paraguay, of all countries, it's a South American country that's kind of in between all the bigger ones like Brazil and Argentina, was in the city of Chester just last Wednesday to have some preliminary discussions about a sister city relationship with one of the cities in their country. We had a small group gathered right here in the mayor's conference room to discuss that. What's also interesting is that I've been involved, for those of you who know, on some, if you will, diplomatic type trips over to Taiwan, talking to their people, and Paraguay and Taiwan have a longstanding relationship since 1957. So this three-part relationship is really going to be, or has the potential to have some great benefits for the city of Chester and its, possibilities of being part of this growing, blossoming semiconductor industry, particularly when it comes to education and workforce development. November 15th is really why Paraguay was in Chester. They're kind of scoping out Subaru Stadium and everything involved in that, because the country of Paraguay is playing the U.S. men's national team on that day. So if everything falls in place, we are looking to do an official MOU, Memorandum of Understanding, Sister City Agreement between the two countries on that day with a formal ceremony. So this is a big deal. Chester has been insular for so long. Everything has to be in, from, and by Chester. To make these connections in the county and the state on the federal level and internationally is really putting Chester on the map as a place of progression and a place that developers, investors, and future residents will be attracted to. So that's my good news. Or that's my news. It's all good.
Great. Thank you, Mayor. Anyone else on the committee want to share anything before we move on? Great. Thank you again, Mayor. Thanks for everybody who is working hard, from law enforcement to community groups on those really important issues. So that is wonderful to see. So let me go ahead and get the slide deck set up here for the committee. We do have some pretty significant news today that I want to report on to the committee, that I just basically informed them prior to starting, and that is. Today, my office filed a plan modification, a recovery plan modification, impacting the Chester Water Authority. And what I'd like to do is talk to you all here in terms of kind of what that means, what we did, and while I get this thing set up, let me just go ahead and do that. I apologize, everybody. There we go. Okay, let me go ahead and share this. Pardon me, everybody. All right, can everybody see that? Great. So let me talk today about a plan modification that was filed about an hour ago. This will be an update that was filed today in Commonwealth Court by my attorneys and Campbell Durant. It was just accepted by the Commonwealth Court a few minutes ago. We will be updating you on that, and we will also be giving you an update on the bankruptcy court sanctions also related to the Chester Water Authority. So let me start a little bit, taking everybody back here for those of you who are not familiar with this and are wondering what is a plan modification. So under Act 47, which is the Municipalities Financial Recovery Act, that is a 1987 law that's designed to help municipalities who are facing financial trouble basically recover. And that is the law under which I am appointed, under which I have my powers and my responsibilities, and is what also governs Chester receivership. So under Act 47, municipalities that are in receivership file things called recovery plans in Commonwealth Court. And those recovery plans, as most of you know, can be amended and modified as needed. We've done this several times over the past couple of years. This, I think, is actually my first plan modification. The other ones were done under Receiver Michael Dowry, but we filed one today, and that recovery plan, that plan modification has two critical points to it. The first is we are seeking to preserve the value of the Chester Water Authority by seeking financial information in light of the newly announced 14% water rate increase for CWA ratepayers that CWA announced and that CWA said was going to be effective January 1st of 2026. The other thing that we are doing through this plan modification, very important, and I put this on par with the bankruptcy filing we filed about 2 years ago, and the other plan modification that we filed about 2 years ago that got to the Pennsylvania Supreme Court. The second part of the plan modification today is to address the unconstitutional composition of CWA's board. We're going to talk a little bit more about that. You all may have remembered, those of you who have been following this, about a year ago, we talked about the special legislation that was passed that impacted CWA and the city of Chester only. That is unconstitutional in our opinion. And we are taking action today to, from our perspective, right that wrong. So let's first start with I would call probably the easier of the two parts of this plan modification, and that's talking about CWA's rate increase and talking about the financial information that we are asking the court to require CWA to provide us. So many of you know, a couple of weeks ago, CWA had what I would call sort of a surprise email and letter to ratepayers announcing a 14% water rate increase that would be effective January 1st of 2026. We talked a little bit about that on the MFRAC on October 14th. You can read more about that on our Facebook page or on the link as well once we post this PowerPoint slide. And so what we're seeking here, I want to be very clear about what we're seeking here in this first part of the plan modification. We are seeking information that is commonly considered as part of rate increases, things like revenues, expenses, capital needs, et cetera, to understand why a 14% increase, and why CWA used, in their words, the fact that they were facing, quote, serious challenges. So specifically, I just won't go through every one of these, but the next three slides will show exactly what data points we are asking the court to order the Chester Water Authority to provide to us within 30 days. These are not, just to be clear, these are not data points that I just made up or we got off the internet. We asked our engineering expert, HRG, to provide us with information that is commonly used as part of the evaluation of rate increases. Because what's different about the Chester Water Authority versus other entities is other entities, particularly private entities, anytime they raise their rates or want to raise their rates, they have to put on what's called a rate case in front of the Pennsylvania Public Utilities Commission. And what they've got to do over there is effectively justify the reason for the rate increase that they're asking for. And it's up to the PUC to determine what rate increase they may use. CWA is not under that law. They can effectively do pretty much whatever they want to do. And so from our perspective, again, from our concern, which is really about the value of the asset, the value of CWA as an asset, we're concerned about CWA's own language of referring to themselves of serious concerns that they're facing. So in terms of the information that we are seeking, and all of this is enumerated in the plan modification, is any rate study conducted for the purpose of the 14% rate increase, actual water revenues and expenses, year-to-date water revenues and expenses in detail, the adopted water revenues and expenses budget by line item, significant customer changes between 2022 and 2025 and the associated annual revenue impacts, any rate resolutions between 2021 and 2025, the annual water delinquency rate, capital improvement, debt, anticipated new money or refunding, individual water service agreements, copies of any violations, notice of violations, consent orders, et cetera, and the existing unrestricted cash balances of all water funds. So again, these are, I want to be very clear, this is information that is typically considered by experts when evaluating an authority's financial condition when they are raising rates. And again, we are not seeking, I want to be very clear here, we are not seeking to block the rate increase, but we're seeking information from it. And of course, also what we're asking the court as well here to do is once we get that information, we want to make sure that CWA would answer any questions that either I would have or my designee regarding clarification of the previously provided information. So again, here's why we're doing this, right? And want to be clear, we're not trying to block the rate increase. Whether it's communities or otherwise, rate increases are often needed to cover rising expenses and critical investments, right? Inflation goes up, prices go up. Rate increases it's not abnormal to see rate increases. But what is important is we need transparency into those. We need clarity. And putting aside whatever fights that my office and the CWA have had, we really want to get down to the facts on this. That is my responsibility as the receiver. to preserve the value of the interests that we believe that I have and the city has in these assets. And we want to restore accountability, and we want to restore confidence. We want to get down to the brass tacks of this. And again, I, as the receiver, I have just as we did with the Stormwater Authority in the previous plan modification, I have a responsibility to preserve the value of a key public asset during the city's ongoing bankruptcy. A couple of things just worth noting here, just again for the public. This type of independent review is different than like a regular audit. So the Water Authority does get audited each year. The level of detail we're looking for is much more detailed. And you can't just use a regular annual audit in order to determine the appropriateness or inappropriateness of a certain water rate increase. And this, would probably be even at a basic level, probably only a fraction of what would be required for a privately run utility in a rate case in front of the Pennsylvania Public Utility Commission. Those are pretty significant undertakings. If any of you have seen those or been part of those, there is a lot of analysis that goes in there. That is a pretty detailed process. It takes months and months and months. That is not what we're asking for here from the CWA. We're asking for some pretty basic information. And what that will allow us to do, and I think the public also has a right to know this, will help us assess what's driving the increase and what operational issues might need to be addressed. So that's the first part of the plan modification. The second part of the plan modification deals with a very, very significant issue, and that is how the control of CWA was stripped away from the city of Chester back in 2012 in a way that is clearly unconstitutional. As a result of that 2012 legislation, which was called Act 73, we are asking the Commonwealth Court to reconstitute CWA's board of directors to consist of 5 members appointed by the city of Chester instead of its current makeup of 3 members, each from the city, Chester County, and Delaware County. We believe that this will correct an injustice that was unconstitutional and would return control of CWA to the city, which created it and controlled it for more than 8 decades. So in terms of some background, and again, I would refer many of you back to the presentation that we made on September 24th of 2024, so a little bit over a year ago, of how Chester lost control of its water system. But in terms of like just the facts of what occurred, the CWA was incorporated by the city of Chester back in 1939. And even back then, it provided water across Chester and Delaware counties. In 2012, the Pennsylvania General Assembly approved an amendment to the Municipality Authorities Act that fundamentally reshaped CWA's board. And that has had an impact on the city of Chester and its residents today. And so when you would have a law that is as significant as that, normally that type of law would be discussed. You'd have public hearings, you'd have committee hearings, you'd be taking public input. There would be a lot of vigorous debate about something like this, which is, again, very, very unusual. But there were no hearings. There was no comment from elected officials from the city of Chester, and city residents had no idea that this was occurring. Instead, the language that took away control from city residents and from Chester City Council, without any compensation, by the way, was very quietly inserted into a bill as an amendment late in the legislative process, really when nobody was paying attention. This was during the budget cycle. And what's more, that language never mentioned the Chester Water Authority by name. But it impacted the Chester Water Authority and the city of Chester, and only the Chester Water Authority and the city of Chester. And that brings us to the reason for the plan modification. So there's a concept in the Pennsylvania Constitution that's referred to as special legislation. And under Article 3, Section 32 of the Pennsylvania Constitution, laws that are designed to affect a single locality are called special legislation, and they're prohibited. Because back in the day, what used to happen was the General Assembly would pass a bill that would only impact one community or one company, and they would either provide them with benefits, such as a tax break, or they would punish them. And what Article 3, Section 32 of the Pennsylvania Constitution prohibited, and it's true of other state constitutions as well, is it prohibited that practice. And what is clear in the plan modification, as we set out, is that Act 73 was written so extraordinarily narrow that it could only be applied to the CWA, even though it didn't use the name Chester Water Authority. It applies solely to a single municipal water or sewer authority that provides services in at least 2 counties and has physical water or sewer projects in more than 2 counties. So the only water authority, the only sewer authority, the only entity that fits that description is the Chester Water Authority. That's it. And that's happened for 13 years. That bill has been on the books that change has been in the books for 13 years. And so while CWA serves customers in Delaware and Chester counties, there is a portion of its reservoir that extends over the border into Lancaster County. And so our point is that one of our points that we make in here as evidence that this is special legislation is that this little geographic quirk was deliberately used to create a class of 1, essentially the Chester Water Authority, and is special legislation by definition. So to be clear on this, just to take a moment on this, and again, this is going to be debated and this is going to be in front of the court, but I think it's important for people to recognize, is that under Act 73, the change of the board only applies to a single municipal water or sewer authority. So that's the Chester Water Authority that was incorporated by one municipality, the city of Chester. But it needs to provide services in at least 2 counties. The Chester Water Authority does to Delaware and to Chester counties. And it needs to have physical water or sewer projects like a reservoir, like a pumping station, in more than 2 counties. And so what's really strange about this, right, if you read that language, is if a water or sewer authority only provides services to residents in 2 counties, like the Chester Water Authority does, it requires for that to apply that it have water or sewer projects in more than 2 counties, meaning 3 or more. And so again, what that effectively means is that for an authority that provides services to residents in 2 counties, it has to have a water or a sewer project in a county where it does not provide services. So the really strange thing about the Chester Water Authority and that language, right, and how narrowly targeted it is that if the reservoir, the Octorara Reservoir, was not part of Lancaster County and it was wholly part of Chester County, that provision would not apply. And the city of Chester would still have been able to appoint all 5 board members. It's a very, very, very strange quirk. It makes absolutely no rational sense whatsoever. And from our perspective, it is one of the key tells that this legislation is special legislation intended to impact the Chester Water Authority and the city of Chester, and only them. And as a result, it is unconstitutional under Article 3, Section 32. And that's why we are asking the court to return the Chester Water Authority Board back to its historic format of 5 members appointed by the city of Chester. We will be posting the full filing, which again was just accepted by the Commonwealth Court about a half hour ago, and we will be putting that on our website. So in terms of next steps, according to Act 47, and again, this is all before the Commonwealth Court. So I just want to be clear that this is the information that is in the timeline that's in Act 47. Certainly the court has the prerogative to do what it seeks to do. But according to Act 47, the court may hold a hearing within 30 days of the filing and must rule within 60 days of the filing. Any additional actions by the court, if warranted, from our end, would be presented in accordance with Act 47 and the court's orders. So that is the plan modification. I wanted to highlight just one thing to just close one loose end as well that we provided some information on a couple of weeks ago, and that is sanctions against the Chester Water Authority's attorneys that occurred in bankruptcy court. So we have talked about The lengths that CWA and its legal team have gone to keep from turning over documents, documents that were ordered by the U.S. Bankruptcy Court to be turned over as part of the bankruptcy process. That is a right that the city of Chester had. This is something, this information was ordered by the court to be turned over. And we sought this information as part of the city's right to find potential bidders for its water assets, including the Chester Water Authority. So back in February of this year, Judge Ashley Chan of the Bankruptcy Court ordered CWA to turn over financial documents and other operating records to the city so that it could solicit bidders, which is a process known as a request for proposals. CWA, though, refused to comply with Judge Chan's orders to do so in a timely manner. And on June 18th, the city's attorneys had to file a motion with the bankruptcy court to compel CWA to act. Now, remember, at this point, the court had already ordered this information to be turned over. On the day of the hearing that the court was going to hear that motion to enforce, CWA turned over nearly 12,000 documents that were sought by the city. And so we had to spend, the city had to spend quite a bit of money needing to get CWA to comply with Judge Chan's order. And as a result, we filed a motion for sanctions against the Chester Water Authority's attorneys. On October 23rd, so just last week, Judge Chan ordered CWA's attorneys to pay $135,575 in sanctions following a finding that they, quote, this is the judge's language, obstructed discovery in bad faith, close quote, by refusing to turn over the records in a timely manner as ordered. That amount of the sanctions represents the city's legal expenses related to those efforts to obtain the documents. These were legal expenses we did not want to spend. We did not think we should have had to spend. This doesn't even include the legal expenses that CWA, through its ratepayers, had to expend on these bad faith actions. And we do have that ruling and that order linked through this slide deck. In terms of what the court wrote, so this is the court's language in the order, and this is from Judge Chan. Quote, "These circumstances support the court's inference that CWA's conduct was intended to hinder and obstruct discovery in bad faith as part of its efforts to interfere with the RFP process it has vehemently opposed since the plan proposed it. The court sincerely doubts that CWA would have ever made further production without the pressure applied by the motion to enforce, justifying the court exercising its inherent power to sanction counsel for CWA in this matter." Sanctions by a judge is a pretty unusual thing to have happen. You don't normally see attorneys fined in matters, but you also don't necessarily see attorneys behave and in this manner as well. It's part of the reason why we are seeking the information, the financial information, as part of a plan modification as opposed to a right to know request. Because frankly, we don't believe such information would be provided to us absent a court order. And that's, again, part of the reason why we needed to file the plan modification. We're obviously grateful for Judge Chan's ruling. It makes it crystal clear that CWA improperly interfered with the city's rights to access these documents. And again, regardless of where you fall on the argument of do you monetize or not, the city does have rights. It's got rights in bankruptcy court. It has rights otherwise. Frankly, that's also part of the reason that we're filing this plan modification as it relates to the unconstitutionality of the CWA's board. It is not fair and it is not appropriate to treat the city any differently than any other municipality in the Commonwealth. It's not appropriate for the city, for people to feel that they can treat the city of Chester inappropriately. And if it takes us going to court to have to make sure that those rights are recognized and preserved, we're going to do it. And if it takes us filing sanctions against attorneys who are acting in bad faith, we're going to do it. We would rather not do it. We would rather be focused on trying to find a consensual agreement with all parties. But if that's not going to happen, we're certainly not going to sit on the city's rights. And so, in terms of next steps, there's going to be, I think, quite a bit going on over the next 30 to 60 days, both in terms of this plan modification as well as what's going on in bankruptcy court. And I will certainly keep the MFRAC committee up to date on what's going on here, as well as what's going on in the bankruptcy court. So, with that, I'm happy to answer any questions that the committee members may have, or if there's any comments that the committee members may have.
I have a comment, but I have to excuse myself from the camera because I have a prop that I have on my cork board. Hold on one second. Sometimes people don't believe we don't have a pre-meeting before these MFRACs, and I'm going to always stress that we don't. Like, we sit here and hear this information for the first time every time. So you've said a mouthful today, Mr. Receiver. I've received this note. It's dated 10/4/2025. I'm going to flash it up really quickly, only to show that it's handwritten. And I love handwritten notes. It's from a resident of Chester. And she expresses that as a voter and taxpayer, we all need Chester Water to remain as a public, community-focused utility. But it's this sentence that really stands out to me. We cannot handle any more increases in our budget. So I'm sure what she's referring to is rate increases. You very accurately said that whether it's a utility or whether it's a municipality like ourselves, you know, and in our cases, taxes go up as expenses may not cover or revenue is not coming in. You know what it takes to keep the lights on, keep the people paid. For a guy who works for a utility, we understand that you have to cover expenses and especially the critical infrastructure out there, the pipes in the street. What I didn't hear you say, though, is that I believe it's a 14% increase that's being proposed for next year. There have been increases these past 3 years. I would say more in the normal range, maybe 5 to 8% increases in the last few years. But I'm always kind of disappointed at the Save CWA campaign, the propaganda campaign that Chester Water Authority has created. And it always seems to me, and I could be absolutely wrong, but the results sort of speak for themselves. It's a campaign that's been embraced by every community outside of the city of Chester. It's that campaign that seems to pit everybody outside of Chester against Chester, as if to say that if this thing goes private, and that's what they seem to be wanting to rail against, rates will go up substantially. What we're seeing now is that rates are going up substantially, and there hasn't been any move, whether it's a private owner or a public owner. We're nowhere close to getting to that point, but rates are increasing, and for next year quite significantly. So to a resident like this, I won't name her, but she's well aware that rates, or maybe she isn't aware, but she just knows she can't absorb rate increases. I will always argue on behalf of any utility or taxing authority that rates will go up, whether it's rates, fees, or taxes for just normal course of business. Things will never stay the same. But I applaud you, Mr. Receiver, for going to bat for the city of Chester with regard to this very large increase that no one has anticipated, that is not a result of a sale or a monetization, and that the evidence that a rate increase is justifiable, should be laid out on the table. With regard to your other point, the reconstruction of the board, as you were talking about it being unconstitutional, I was waiting, I guess, for what was unconstitutional. But then you finally did get to that, the special legislation. I wasn't aware of that point at all. So thank you for making that very clear on how targeted the legislation was. And I was sitting in my mind, it's like, I know another utility that serves two communities, but the fact that it's two or more, having some assets in more than two counties really makes that difference there. So thank you for your work.
Absolutely, Mr. Mayor. Thank you. And again, we understand some of the stuff gets a little bit in the details and the weeds. It's why we have good attorneys, who will be hashing it out, in front of a judge. But again, this is I think a lot of what has been asked for, and again, folks who may be upset about what we're trying to do over here, is we were simply asking for the city of Chester to be treated like every other similarly situated municipality in the Commonwealth. This is, we're not asking for special treatment over here. In fact, we're trying to make sure we're not being treated differently. And if it impacted other entities, that would have been evidence that it's not special legislation, but it was very much targeted. And if folks read the plan modification, which goes into great detail in terms of our argument of why it's special legislation, you'll understand why. And again, hopefully I'll have an opportunity to provide information to City Council, maybe at their next meeting, in a little more detail about what this looks like as well. And certainly do appreciate the attention and the care that this committee is giving these issues as well. So, did anyone else have any other comments or any other questions before we close?
Well, let me make one other point. Like save CWA, just that term itself kind of bothers me personally, because nobody wants CWA to go away. This area, this region needs a good water utility, and we have one in Chester Water Authority and its efforts to bring clean, safe, good drinking water, especially to the employees who have oftentimes come to me and says, "Hey, what's going on over there?" I'm like, well, you're the key asset to this company. If it's bought, if it's monetized, like you're that key asset. I've worked in this water business. I know how few people, young people, are entering this as a career. Like there's nothing more valuable to these companies than the people who work there. We can't find enough of them. I mean, that's no matter how this utility ends up serving this area, and it will continue serving in this area, it's going to be serving this area with many, if not all, of the people that's working there now. Enough said.
And to be clear, just so folks again know, the Save CWA is actually part of the Chester Water Authority. It is not an independent group. It's funded by the Chester Water Authority. The Chester Water Authority hired a consultant to essentially staff it and paid that consultant about $319,000 through mid-November of 2024. So again, just putting the facts on the table over here, those are ratepayer dollars that are being used in this campaign. And again, that is up to the Chester Water Authority to do. It's up to the Chester Water Authority to decide whether they want to continue with a very expensive legal strategy that they're not being transparent with in terms of the fees that are being charged and being paid for on ratepayers. And again, as part of our concern as well too, as part of the financial condition are some of those fees and some of those expenses causing CWA to have a lower cash on hand, for example, than other utilities, have a lower debt service coverage than other utilities. Those of you who received the letter from CWA talking about the 14% increase and fully putting the blame on the city, that letter conveniently omitted the second broad factor that Moody's looked at when it downgraded CWA's debt, and that was the loss of a significant wholesale customer that CWA had in a little bit before 2023. And that same Moody's downgrade pointed out that relative to other highly rated utilities, that CWA had a low cash on hand, which basically means they have a low checking account relative to other high ranked entities, and that has nothing to do with bankruptcy. That has nothing to do with the city of Chester. That has nothing to do with the receiver or my team. And again, it's a little bit disingenuous and a little bit disappointing to see ratepayer dollars be used to send out letters like that which are not fully accurate. So with that, I will have said my piece. Any other questions that folks might have or any other comments on the committee? Great. Seeing as that, we will we'll end the meeting for today. We will be back in November. I wish everybody a good rest of the week, and we'll see you at the next MFRAC in November. Thanks, everybody.